So good afternoon, everyone, and welcome to today's event at Durham University's New Frontiers in Environmental Adjudication Dialogue with the Judiciary from Around the World series. My name is Katalin Suyok. I'm Associate Professor in International Law and Sustainability here at Durham University at the Law School's Just Transition to a Net Zero World Research Group. And it is my great pleasure to be hosting today's session. A warm welcome to all of you who are joining us online for what promises to be a very rich and illuminating conversation. Climate change confronts domestic courts across the globe with remarkably similar set of dilemmas about rights and responsibilities, the reach and content of legal obligations and principles, and altogether our obligations and responsibilities owed to present and future generations. And yet the legal responses that emerge from the case law are rarely, if ever, entirely uniform across the jurisdictions. The local environmental, social, cultural, and political context does shape the ways in which courts answer these questions. Courts at all levels, both domestic and international courts, are crucial players. They are not merely applying and interpreting existing law, but they are also shaping the ways in which the society views the environmental and planetary challenges. Courts are mainstreaming certain basic scientific facts and truths around climate change and the ecological crisis in the public discourse, and they provide an authoritative narrative about what climate science and climate justice should mean in various legal contexts. It is that comparative richness and the common threads that nevertheless emerge in the various jurisdictions that our online series seeks to explore. It is my very great honor and pleasure to welcome Justice Nambita Dambuza, a judge of the Constitutional Court of South Africa, for today's event. Justice Dambuza has an extraordinary judicial experience. She serves for 11 years as a judge at the High Court in the Eastern Cape Province, and she also sat on the Competition Appeal Court. She then spent a decade as a judge of the Supreme Court of Appeal. She has previously served as an acting judge of the Constitutional Court, and in May this year, she was appointed to the Constitutional Court of South Africa as a permanent member. This is South Africa's apex court on constitutional matters, which is also widely known internationally for its case law. Justice Dambuza will be addressing the complexities confronting courts as they seek to develop guiding principles for sustainable development in a developing country context, with South Africa as her case in point. A brief note on the format. Justice Dambuza will speak for approximately 30 minutes. Her presentation is recorded and will be made available online following the talk. We will then move to a roughly 30-minute question and answer sessions, which will not be recorded, and I very much hope that you will all engage fully and freely in the conversation. Please join me in warmly welcoming our guests today. Justice Dambuza, the floor is yours.
Thank you very much, Catalina, for that warm welcome. I thought I would phrase my talk in this manner because, in a sense, South Africa is in somewhat of a unique position when it comes to environmental jurisprudence generally on sustainable development. South Africa is one of the highest carbon emitters globally per capita. The last time I looked, we were number 12 in the list of emitters in the whole wide world. And of course, we're number 1 in the continent of Africa. And so it is a country that cannot hide entirely behind poverty and unemployment and all the traditional factors that affect developing countries. Yet it has to, because a large component of its population lives beyond below the poverty line. It is a country that is resource rich and has a highly industrialized economy compared to its immediate neighbors on the continent. However, the benefits of such relative wealth and economic success are not evenly distributed through the country. The legacy of apartheid continues to impact vast numbers of South Africans in rural and urban areas similarly. Whilst the wealthy and middle class have enjoyed the benefits of democracy and the transition to the constitutional order, at least 2/3 of the population remains impoverished. The country has the highest rate of social inequality in the world, and over 30% of our population is unemployed. And corruption continues to limit our economic and infrastructural development, with our poorest citizens bearing the brunt of all of this. Our energy generation remains reliant on coal and oil, with electricity largely provided by an aging fleet of coal-fired power stations, leading to energy insecurity and regular power outages throughout the country. And against this backdrop, South Africa enjoys a very progressive constitution in which environmental rights are explicitly protected and given equal weight along the traditional liberal rights like freedom of speech, property rights, habeas corpus, and political rights. Section 24 of the South African Constitution enshrines both negative and positive environmental rights. As a baseline, it guarantees the right to an environment that is not harmful to a person's health or well-being. It creates a positive obligation on the state to protect the environment for the benefit of present and future generations. It requires that legislative and other measures be put in place to prevent pollution and ecological degradation. And this section 24, has been described as one of the most expansive and sophisticated codified environmental rights in the world. And it attempts to reconcile two often conflicting imperatives, which in our society are crucial, and also in many other developing countries. On one hand, a healthy environment is essential for well-being and flourishing of all people. It is both a right and a state obligation under our Constitution. This is increasingly significant in light of the intersecting environmental catastrophes confronting us today, with impacts of biodiversity loss, resource depletion, and climate change overwhelmingly impacting on the most disadvantaged in society, further exacerbating the societal problems of poverty and inequality. On the other hand, economic development, especially resource extraction and industrialization, is seen as an essential tool for generating the wealth and creating employment that is so much needed to address the inequality and diverse social problems present in our society. In this context, as South African judges, we are grappling with the interpretation of Section 24 as a codification of the widely accepted definition of sustainable development. The use of natural resources must meet the needs of the present without compromising the rights of future generations. And so in our role, we are called upon to determine environmental disputes through the prism of sustainable development, and to do so in a manner that recognizes that environmental rights are multifaceted, that they encompass the environmental, the economic, and the social considerations. But in cases presented before us, sustainability and development are always cast as opposing paradigms rather than the composite objective expressed in the Constitution. And you add to that the imbalance in skill and resources between some of the state parties that present cases before courts, institutional constraints on state parties and communities, lack of capacity and reliance on overextended state attorneys becomes evident in the pleadings in these cases. Private litigants and corporations, on the other hand, particularly wealthy private litigants, are able to engage highly specialized experts to formulate proactive litigation supported by comprehensive research. Communities that are affected by the environmental degradation and who lack the necessary resources can only rely, and heavily so, on NGOs for enforcement of their environmental rights. Nevertheless, our National Environmental Management Act, which is South Africa's overarching environmental law framework, often is implicated in the disputes that serve before the courts. It is a framework that attempts to reconcile environmental protection with economic development. And its objective is not, strictly speaking, that of environmental protection. It is more aligned with the realization of an environmentally conscious economic development. And its language and framing still strongly reflects the sustainable development paradigm of the International Environmental Conventions of the 1990s and the 2000s, which have since been highly criticized for failing to adequately address escalating environmental degradation directly caused by economic development. It is usually through these instruments, in any event, that is the Constitution and the NEMA, National Environmental Management Act, that courts determine environmental disputes. Our Climate Change Act has just been promulgated I think it's about 2 years old only at this time. So how have the courts then interpreted the framework and some of the legislation enacted under it? First, I look at the jurisprudence of the highest court, the Constitutional Court, which in many ways reflects the attempt to reconcile environmental protection with economic development. In the early cases, such as one case, de Kock, a 2005 case, Mr. de Kock, a self-represented landowner, wanted direct access to the Constitutional Court to compel the Minister of Water Affairs and Forestry to force a steel conglomerate, ISCO, to address severe pollution that affected his land. The Constitutional Court, however, refused direct access, stating that although his claims raised public interest issues, the complexities involved required initial consideration by the lower courts. What has come out of comments of the jurisdiction coming out of the various courts is that the lower courts tend to be more forthright in environmental disputes resolution and protection of rights, and more enthusiastic to assume jurisdiction than the Constitutional Court is. But in fuel retailers, a case that the Constitutional Court heard 2 years after the COC, the court, when setting aside a fuel retailer permit, made several key pronouncements. First, it highlighted the crucial role that courts play in environmental protection. Second, it acknowledged the intergenerational dimension of environmental protection, and it affirmed that a healthy environment is an essential prerequisite to realizing other rights that are protected in the Constitution. Third, it affirmed the rights of future generations, emphasizing that the environment must be protected for the benefit of present and future generations. And fourth, it held that environmental considerations must be balanced with socio-economic concerns through the ideal of sustainable development. In a frequently cited passage from this case, the court emphasized that, and I'll quote, "Development cannot subsist upon a deteriorating environmental base. Unlimited development is detrimental to the environment, and the destruction of the environment is detrimental to development." The criticism, however, is that whilst these pronouncements were commendable when they were made in the mid to late 2000s, sustainable development and the idea of integrating environmental, social, and economic considerations is outdated given the global ecological crisis and resource scarcity of today. A further complaint is that the courts usually have failed to interpret the words health and well-being in Section 24 of the Constitution. However, a decade after fuel retailers, the Constitutional Court interpreted the term well-being in Section 24 to include all sentient beings, thus connecting animal rights to environmental rights and giving content to the term well-being in Section 24 of the Constitution. The criticism, however, persists that the Constitutional Court's jurisprudence leans very heavily on procedural grounds, particularly prior consultation and consent for development activities, and that instead of interpreting and developing the right itself, for example, whether it is a self-standing right or depends on other rights for realization by the state, the court merely resorts to interpreting NEMA, the Act, the framework. It is said that the Constitutional Court may thus be said to have developed an environmentally friendly jurisprudence without substantially developing the environmental rights themselves. But in my view, this may be a consequence of the pleadings, what is presented to the courts, which is what is not adverted to in the criticisms. Section 33 of the Constitution protects the right to just administrative action. This is often the basis on which environmental challenges are brought to courts. A framework that facilitates participatory democracy and respects community autonomy. Community autonomy is especially pertinent in the post-apartheid era, as indigenous communities had virtually no control over the land on which they lived before South Africa became a democracy. So in this context, environmental and other procedural rights are inextricably linked. And usually this is how the disputes are presented to court, or that this is how they are framed. This is what the Constitutional Court emphasized in Fuel Taylors. So as far as I can observe, in South Africa, sustainable development will still be central to determination of environmental disputes brought before the courts. The difficulties pertaining to its imprecise nature persists, especially in its interpretation in a concrete manner on its own, as I have said, without reference to more clearly defined constitutional rights. Sustainable development remains a non-prescriptive concept. And perhaps this is by design, such that it remains sufficiently flexible to adapt to changing circumstances, which suits a developing country such as ours. In this sense, it is similar to lack of precision in any event in the interpretation of sustainable development as a principle of international law. In the recent past, there have been a few judgments, mainly from the Middle Court and the High Courts, where the courts have engaged more closely than before with the difficulties of reconciling environmental rights with economic development. In South Durban Community Environmental Alliance, which I had the honor of scribing, the Supreme Court of Appeal set aside the approval for a gas power plant, partially on the ground that the government had not considered more environmentally friendly alternatives, which on the evidence had been presented. In that case, we further drew a direct link between the global climate crisis, its impact on communities, and the importance of considering the cumulative effects of environmental degradation when considering major developments, particularly with respect to energy power plants. We set out what we hope provide guidance to achieve an appropriate balance between environmental protection and economic development. Again, the same court in Groundwork Trust, both the High Court before it and the SCA addressed the positive obligations that are imposed on the state in the context of exercising its regulatory powers under the Framework Act. The case centered around a decision by the Minister of Environmental Affairs not to exercise her regulatory power to implement a plan that had been agreed on in relation to reducing the high levels of air pollution in communities surrounding a series of coal mines. Importantly, these decisions are still centered on the tangible impacts of environmental degradation on impoverished communities as a matter of rights, rather than as a procedural failure in consultation or compensation. They concretize the duties of the state actors in relation to the environmental impacts of economic development, moving beyond a duty to consider and balance interest to an enforceable duty to actively mitigate harm. In African Climate Alliance, which is the first South African case brought by an association of the youth. The High Court set aside the government's failure to consider the cumulative and intergenerational impact of greenhouse gas emissions in a decision to approve yet another coal-fired power plant. So in conclusion, the determination of environmental disputes through the prism of sustainable development still presents a primary challenge in our jurisdiction because of the historical and current social context. The balancing of urgent socio-economic development, eradication of poverty, inequality, unemployment against decarbonization, climate resilience, and ecosystem preservation is a complex exercise. And I do admit that courts do struggle to develop an environmental law jurisprudence that adequately balances these demands or does so to everybody's content. But there is progress. And law has always been an evolving science to some extent. These concepts still continue to evolve in our country as well. Thank you very much for listening to me.
Thank you so much, Justice Dambuza.